So welcome to all our listeners. Today, I'm very excited to be talking to Dr. Theresa Squatrito. She's an assistant professor in the Department of International Relations at the LSE. Theresa has written an article for the Review of International Studies, or RIS, as the journal is commonly known, and it's on judicial diplomacy, international courts, and legitimization. A very warm welcome to you, Theresa.
Thank you. Thanks for the invitation to be here.
So we have 15 minutes, so we'll get straight onto it. So let me start by asking you about your academic journey and really what led to your interest in this area of research.
Yeah, so I've been working in the area of international institutions for quite some time now, and I've really been intrigued generally by legal institutions, international institutions. So I've been studying international courts and looking primarily at issues around kind of how they're designed or what the core rules governing international courts and their functions are, and more recently how they're performing these functions and or behaving as political actors. So traditionally, both IR scholars and international legal scholars have primarily been concerned with how international courts, such as the European Court of Human Rights, the European Court of Justice, or the International Criminal Court, how they practice law. So how they interpret the law, how they construct legal arguments, how they settle disputes, how they drive compliance, these sorts of things. And so when I started in looking at some of these courts in more detail, I started to notice that they're actually conducting a lot of activities outside of the courtroom, or what we might call off the bench. And this could include anything from, hosting conferences or seminars to having meet and greets with state officials or developing comprehensive public communication strategies. So I became really intrigued by these sort of off the bench activities and really wanted to kind of understand how we can think about these activities and why international courts are actually engaging in them. They don't seem particularly relevant to the law or courts from just a kind of a layman's perspective. So that's really what got me on this topic.
That's good. And you've actually given us a nice little outline there of what your article is about. So perhaps I can move on to some more specific questions, if that's
Sure.
all right. So in the article, you've developed this concept of judicial diplomacy.
Yeah.
Could you explain to us what it is and how pervasive it is?
Sure, yeah. So basically, I should first start with the idea of diplomacy. So diplomacy is nothing new to international relations scholars, but what I think is important to notice about the way in which the concept of diplomacy has evolved is that it actually captures a wide set of practices. I think in kind of, common political discourse, we just think of diplomacy as face-to-face dialogues between top state officials, but it's actually a lot more than that. And the other thing is that it's a concept that has come to be used in reference not just to state officials. It's also used in reference to, say, international organizations, NGOs, parliamentarians, a whole wide set of actors. So for me, I end up defining judicial diplomacy as the set of practices that are planned and organized by international courts in which or through which they can represent themselves and claim authority through non-adjudicative interactions with external actors. And that ultimately means that it carries four kind of key features. And that is, it's a decision taken by the court and conducted on behalf of the court. This isn't judges going out there on their own kind of initiative to engage with, say, a legal community. This is a decision by the court itself. And it reflects the court's efforts to build relationships with external actors. At the same time, it includes a variety of activities that can range from anything, like I said, dialogues with government officials to representation at international meetings to even forms of public communication like having social media profiles. And last, I should be clear that for me, judicial diplomacy is separate from the process of adjudication. This isn't about a court interpreting the law or settling disputes. It's something else. And from my cursory kind of overview of international courts overall, a lot of courts are conducting these activities. It's old courts, it's new courts, it's courts in the area of trade, it's courts in the area of human rights. So it's quite pervasive, I would suggest. So yeah.
Okay, so what would that's very interesting. What would the reasons be why these courts are conducting this judicial diplomacy?
Yeah, so I in this article think about the reasons why they're conducting judicial diplomacy, and I begin with thinking about possible reasons by looking at more of the literature or what we know about international law. And there's two main kinds of ideas that come out of that literature. And the first is that these courts may be engaging in judicial diplomacy in order to facilitate the process of compliance, in order to garner greater obedience to the law. And that could be by mobilizing key stakeholders who could basically leverage their influence to encourage states to comply. The second kind of main argument, or which I call the mobilization of compliance constituencies, the second main kind of reason that they may be conducting judicial diplomacy also comes from the international law literature that thinks about how actors can be socialized to embrace legal norms or the law. This again is very much driven by the thinking that it could be about a process of compliance, ensuring adherence to the law. So this is more courts trying to engage in persuasion to get other actors to accept and embrace the law as appropriate. Now, the third kind of reason I come up with is that this may be about a process of legitimation of the courts themselves and not about the law per se. And this account builds and draws more from the broader international organization literature that basically considers and responds to a growing sense that international institutions suffer from legitimacy deficits or they're facing legitimacy crises, and that as a result, they have worked towards trying to build their social legitimacy, where this is really, legitimacy is understood in terms of the beliefs within a given constituency or relevant audience that the institution's exercise of authority is viewed as being appropriate. So this is really kind of at the core of my contribution here, is to think about how judicial diplomacy is a legitimation or is potentially a legitimation practice or strategy on the part of courts, so that they can actually be accepted as appropriate institutions, but also that it has impacts on things like whether or not they get compliance, or whether or not they even get cases in the first place. So yeah.
Okay. So so how are the courts doing this? And what does this tell us about why they're using it?
Yeah, so basically I look at two particular courts to try and decipher and determine to what extent judicial diplomacy is really a practice aimed at compliance, mobilizing compliance, constituency, socialization, or legitimation. So I look at specifically 2 new courts that are from the Global South, and that is the African Court of Human and People's Rights and the Caribbean Court of Justice. And what I look at is questions that think about the extent to which the content of judicial diplomacy reflects whether or not courts are really trying to talk about the law versus whether or not they're trying to talk about the courts themselves, as well as who their primary targets are of their judicial diplomacy. So are they targeting state officials? Are they targeting the public more broadly, or key stakeholders? And what I find is that, by and large, these 2 courts tend to have judicial diplomacy which is public-oriented and people-centered. So in that sense, what I'm finding is that a lot of what they are doing in terms of their judicial diplomacy is really trying to reach out to the wider public. That does not mean that they're not looking towards state officials, and that does not mean that they're not also looking at key stakeholders or potential compliance constituencies. It just means that a large amount of what they're doing in terms of their off-the-bench activities is really trying to improve their public image, so that the people see these institutions as their institutions, or ones that represent them. I also find that a lot of this content then of judicial diplomacy goes beyond talking about the law. It goes towards talking about how the institutions reflect procedures that the people value, such as fairness. It also means that they highlight things like their commitment to their core political purpose, right? So for the African Court of Human Rights, that means that the court isn't just talking about the fine details of human rights law. It means they're saying, look, we care deeply about human rights, and we're here to ensure that human rights are respected. We're not here to have fights with states about what that means. We're just here because we're committed to those purposes. Or in the Caribbean court, they're often saying we're committed to enhancing the rule of law. And they do that not just through the way they interpret or respond to their judicial decisions, but the court itself has developed a number of kind of platforms in which they try to improve the respect for the rule of law across the Caribbean community, and not just through what it does within its courtroom. So that's by and large how I would describe a lot of what these courts are doing in terms of judicial diplomacy. Is one, they're trying to reach out to the public and stakeholders where there seems to be a lack of legitimacy. And they're really trying to develop narratives and present the court as being reflective of the community that they're serving. So I think ultimately, through observing those kind of patterns in the way courts practice their judicial diplomacy, it really suggests that judicial diplomacy is, yes, maybe in part about facilitating compliance, but a large part of it is about boosting the legitimacy of the institution itself. It's about the court saying, we are an institution that is appropriate.
Okay.
So yeah.
Yeah, thank you so much, Theresa. It's very interesting. For those listeners who have, as I have, found this all very interesting, could you just very briefly, because we're running out of time, just in a couple of sentences, tell us and tell them what the sort of main takeaways of the article are if they were to go and read it?
Yeah, so I think definitely one of the main takeaways is to think about non-judicial activities as being crucial to understanding overall the performance and legitimacy and even compliance issues around international law and courts. Second is that these activities are related to legitimation. And that means that those scholars or those who think about legitimation of international institutions could benefit from thinking about international courts. So like I said, a lot of this kind of legitimation literature has only focused on international organizations like the UN or the WTO or the World Bank, but courts are a crucial part of the architecture of global governance that I think this article really kind of tries to get at, and that we could think about them as actors engaging in legitimation. And finally, I think that it suggests there's a lot of room for further thinking about the potential synergies between legitimation and diplomacy that so far, I don't think IR scholars have really quite really honed in on so much so far. And I hope the take-home point is also just let's think about international courts as really important actors in global governance and political actors, not just legal ones. So yeah, that's what I would say are the take-homes.
That's wonderful, thank you. So for those of you who are keen to learn more, you can read the full article on judicial diplomacy in the first view section of the RIS website. If you're a BISA member, you can access this free of charge as part of your membership. You just need to log on to your account. And if you're not a member, you can probably gain access to it through your institution. So I'd just like to close up now and thank you, Theresa. Thank you so much for this fascinating insight into your research.
Sure, no, thanks again for having me. It was nice to be able to communicate my research in a verbal way.
Okay, all right, thank you.